Back to boatslaw.com. My name is Scott Boats. I'm a lawyer in Houston, Texas, and this is an introductory video to child custody litigation in Texas. It's intended for my website, and nothing in this video constitutes legal advice. Nothing in any of my videos on this website constitutes legal advice, so don't take it as such. I want to start out this video by reading about what the public policy of this state is regarding children who are made the subject of lawsuits either through divorce, because if you're getting divorced and you got children together, you've got to divide up the parental rights and duties, or original actions for parentage, establishing who the dad is, and establishing child support responsibilities, that sort of thing. But what's the public policy of this state, the great state of Texas? Well, first, to assure that children will have frequent and continuing contact with parents. But there's not a period there, all right? What kind of parents? Parents who have shown the ability to act in the best interest of the child. Those parents who have shown an ability to act in the best interest of the child. But there's more public policy about what the state's supposed to be doing. Well, the state is also, the government, the Leviathan, is also supposed to be providing a safe, stable, and non-violent environment for the child. And there's just a little bit more that government or the state is supposed to be doing. And that is to encourage parents, you are hereby encouraged to share in the rights and duties of raising their child after the parents have separated or dissolved their marriage. Now, you can, indeed, separated post-copulation, right? So there's been fertilization and you've separated, and the baby's baking inside, and not bacon, hopefully. At any rate, so anyway, that's what the three objectives of this Chapter 153 of the Texas Family Code is all about, and that's titled Conservatorship, Possession, and Access. So the child custody litigation deals with that fundamental policy, the duty of the state of Texas regarding children. The devil in the details relates to allocation of parental rights and duties. Those parental rights and duties will include things like who makes decisions about the education of the child, who makes decisions about doctors and mental health concerns for the child, psychological and psychiatric testing, who makes decisions about where the primary residence of the child might be. And are those decisions bound by a certain number of blocks or miles or counties or states? Are there any limitations in choosing the primary residence of the child? Should child support be ordered? Who should receive it? And how do we make sure that the child is on health insurance? Other issues too. But those are some of the more specific examples of rights and duties. Now, it's not just rights and duties, but allocation. For example, should these and other rights and duties be joint? Should they solely be the responsibility of only one of the parents? Should the rights and duties be exercised only when the child is residing through visitation purposes in one of the residences? So these issues can get complicated, and these lawsuits can be awfully personal. For example, you make a child with somebody, irrespective of whether you married the person who you made the child with. You make a child with somebody. Are you rightful in alleging that they were good for one purpose, but they're not good for another? Or why is it that other parent who may have shown the ability to act in the best interest of the child, why is it that their access and possession should not be the same as yours? If you can't live with the other party, so obviously it can't be 100% of the time with the two of you. And, I'm one of those people who thinks we ought to start out at 50-50 and go from there. That's not quite where we are. But honestly, if you look at the possession orders, it's really not that bad. But at any rate, I think it's reasonable to ask these questions, and even deeper questions. How do you define best interests? There's case law in Texas that gives factors for defining best interest. Courts often order custody evaluation, and that's where a third party will come in and look at the household of the competing parties, the parties who are waging the lawsuit, and provide a report to the court. And that evaluation can make recommendations. And that evaluation will typically gather information that you might not otherwise be able to gather because of monetary constraints or other constraints about the other household. That's a custody evaluation. Courts often order custody evaluations, but courts are not required to order custody evaluations. Courts might also name an amicus attorney to represent the best interests of a child. Amicus means friend, or a Latin root that means friend. Kind of friend of the court. That's amicus curiae. That's a kind of brief that's given to, for example, a court considering ruling on a question. But amicus attorney means really friend of the child. But they're a lawyer, right? They're not a mental health counselor. They're not any other form of counselor. They're an attorney and counselor at law representing the child, and they have certain rights and duties. Lots of controversy about amicuses. Just do your own Google search on that topic, and you'll find out why there's might be controversy. Some of the most important witnesses in these cases are people who are not used to giving black and white answers to questions. Counselors, they can be family counselors, they can be individual counselors, either to either the parties or the children. You see how third-party opinions might influence a judge's point of view. I think the most important aspect to these lawsuits are the child custody evaluation and potentially who the amicus is. These are complicated matters. They are not easy, and they should not be entered into without significant consideration on the part of a parent who might bring the lawsuit as to whether the lawsuit is truly in the best interest of the child or whether the lawsuit is really an expression of ego or an expression of emotion that really does not relate to the best interest of the child. Maybe the better path might be some form of family therapy or some form of individual therapy as opposed to opening up litigation. Anyway, that's a general introduction to child custody litigation, and can you see how these cases can get somewhat expensive? Not an easy decision to make, but I've been party to such lawsuits myself, and I understand the complication. I've certainly represented scores of dads and moms alike in bringing these lawsuits. I wish you the best of luck in your consideration of what to do. If I can help you, send me an email, scott@boatslaw.com. Good luck to you.